Here's a definition of arbitration. It is a private process which disputing parties allow a neutral party to make a legal decision. The decision will state how the dispute will get resolved. Each arbitral decision is made by a single arbiter or a panel of arbiters. Think of arbiters like a judge in a courtroom. An arbiter listens to arguments and examines evidence during hearings. Then the arbiter presents an award as part of the final decision. Most awards are monetary sums that one party pays to the other. Some arbitrators announce each decision but do not provide any reason or details. This refers to a bare bones reward. Other arbitrators choose to provide a reasonable award. This is where parties can hear the specific details to why a decision was made. Arbitration is a popular form of ADR, which stands for Alternative Dispute Resolution. Mediation is another common type of ADR, but it's different from arbitration. That's because an arbitrator has much more power than a mediator does. Arbitrators have the authority to make a binding decision with very limited grounds for appeal. Mediators don't have that level of authority. They can only make suggestions to disputing parties. There are two major types of arbitration: binding and non-binding. The processes for both are almost identical. But there's one key difference. In non-binding arbitration, the arbitrator's award isn't mandatory. Instead, like mediation, the award is only a suggestion. Thus, either party can reject the award and force the other party to a jury trial. Since a non-binding award is little more than an advisory opinion, non-binding arbitration isn't popular. The majority of arbitration agreements will state a binding arbitration must take place. Arbitration holds quite a few more advantages over going to court. One of the major advantages is that parties have a say in choosing arbiters. Parties often select a decision maker who has relevant work or industry experience. As a result, arbiters can understand the basis of presented evidence better than court judges. In fact, this leads to another arbitration advantage: efficiency. Most arbitration cases conclude faster than standard court proceedings. Not only is the process shorter, but the preparation work is not as demanding. Many lawsuits can drag on for years in U.S. courts. Meanwhile, the majority of arbitration cases conclude in a few weeks or months. Since arbitration is so fast, most parties save a lot of money compared to litigating in court. Another advantage of arbitration is that the hearings are private. Unlike court litigation, members of the public media are not allowed to attend. Plus, most terms for final decisions and awards stay off public record. This is great for individuals and businesses that want to maintain strong public relations. Arbitration hearings are also convenient. Instead of following a strict court schedule, parties can arrange a time and place of hearings. As you can see, arbitration is flexible. Just about every court procedure is streamlined and simplified. Do you want to learn more about basic arbitration? If so, go to arbitrationagreements.org. You will be able to watch more videos and read articles on a wide array of subjects. Also, feel free to pick up the phone and call our association if you have any specific questions. Our phone number is 844-554-0444.